May it please the court, Adam Levine for the appellant, Kelly and Carlo Antoshka. Your Honors, this is not a foreclosure case. I'm sure that will be very disappointing for you.
It's good to see you.
This is a premises liability case, and really, in this case, there are essentially two issues and multiple subparts for consideration. This case was disposed of on final summary judgment on the record at 217 to page 219 by the trial court that ruled that Kelly and Carlo Antoshka possessed constructive knowledge of a dangerous area on land, and that because she was a joint owner, the city of Naples and her mother, Ms. O'Green, were entitled to summary judgment in this premises liability case. Summary judgment in this case was improper, really for two reasons. First, under Metzger, which adopted the reasoning of Volusia County versus Aberdeen and Ormond Beach, this court said that summary judgments are evaluated de novo, and it's a two-pronged evaluation. In the first prong of the evaluation, we have to examine whether or not there were any genuine issues of material fact that would prohibit or preclude summary judgment. And all inferences must be taken against the non-moving party, or in favor of, the non-moving party. Here, there are multiple issues of genuine material fact that should have precluded summary judgment.
Well, under Metzger, that was an invitee who went to an RV show, correct?
Yes, sir.
Was injured when an awning fell on them, correct?
That's correct.
Well, there's no doubt that Ms. Antoshka signed the deed to this property in 1995, correct?
That's correct, Your Honor.
She's an owner. Do you have any cases in the state of Florida or anywhere where a co-owner can sue another co-owner in premises liability?
No, Your Honor, I don't. And in looking at the cases, neither I nor my learned colleagues have been able to find any cases. However, logically, this court said in Metzger that it's not whether you're an owner of property, it's whether you have the ability to exercise control over the property.
Yeah, but aren't they talking about the defendants and not the injured party? Because someone owned the property and then someone possessed the property. That's the station of the defendants and their respective liability. Here, your client's neither an invitee, a licensee, and certainly not a trespasser.
Well,
so how does she have a cause of action against her mom when she owns the property upon which she fell?
Your Honor, in this case, whether you're a co-owner doesn't preclude you from being an invitee, a licensee, or a trespasser. And it's easy to look at possible...
What is she? On that particular day, seeing as she used to live there till she was 17 and then lived there off and on for a while, then got married and then visited very frequently, what was her legal status on the day of the accident?
I would argue that on the day of the accident, Kelly's legal status was that of an invitee.
How so?
Because if we look at all the possibilities of a co-owner on property has multiple duties to anyone else that could, or an owner, or an occupier of property, which is some of the earlier cases didn't talk about owners as much as they talked about occupiers of property. If we look at other issues, a co-owner could be a trespasser. If you take any house in Hillsborough County where there's a spousal abuse issue and an injunction for domestic violence, after an order is entered against the abusing spouse, if that spouse enters the house, he could be a trespasser or she could be a trespasser.
Well,
Mom
didn't have an injunction against Kelly in this case.
A landlord-tenant relationship, a landlord could be a licensee or an invitee when they come back to the property.
Kelly wasn't a tenant either, correct?
Kelly was deeded the house in 1995 as part of an estate planning thing. Mrs. O'Green testified in the record that she intended for the homestead property to be hers. She didn't intend for her children to have any part of the house until she died.
Let me ask you this question. If a stranger walks on the property that's invited over to Miss Green's house, he or she trips over this alleged crack and is injured, cannot he sue both Kelly and O'Green?
He probably could, Your Honor, yes.
Because why?
Because they're both technically on the deed to the property.
And they both have a duty.
And
the occupancy by one is
Right.
And they both have a duty of care, correct?
They both have a duty of care, and that brings me to why summary judgment really is also improper. Because a co-owner, if we look at what the duties are under Marion versus Boca Raton, the duties to create a safe environment to warn people of hazards and also maintain the property are independent of each other. So whether there's a duty or not to warn between Mrs. Green and the city versus Kelly, there's certainly an independent duty for each property owner to maintain the property. In that case, the city owns the tree. It should be maintaining all the parts of the tree. And Mrs. O'Green owns the house and the property. She should be maintaining the house and property. And yes, Your Honor could argue, because I'm waiting for the next question, where Kelly also could be told that she has to maintain the property. The difference between Kelly and her mother and the city is, according to the record, the city knew and her mother knew that there was a hazard on the land.
Well,
Kelly didn't know about the hazard.
Wait a second. The record only shows that Miss Green notified the city about the roots in the Greenway area that were protruding from the grass, because she testified she didn't know about this crack in the driveway.
There was some.
So how's the city on notice of these subterranean roots until this accident?
Well, that's a question of material fact, because we don't know that all the roots are subterranean. The only person that said
this is a private driveway, correct?
That's correct.
Well, the city doesn't have a right to go underneath and remove the roots of a private driveway, do they?
Well, they do, because in this case, Mrs. O'Green testified that they'd done that before, or not necessarily under the driveway, but they'd gone and trenched the roots for the tree before.
In the grassy area?
In the grassy area, yes, sir.
That they own, the city owns?
Well, it's a right-of-way. The city doesn't own it.
We call it a
I mean,
curb
it's a right-of-way, a 30-foot right-of-way in the record.
Well, Ms. Green doesn't own it either.
Right. So, but the issue is Ms. Green can't maintain it without the city's input. And that's another issue of genuine material fact.
She can't trim it or prune it.
She can't do anything to the tree without the city's input. She can't trim, prune, trench, or do anything. We don't know that the roots are subterranean, because we don't know that the roots aren't on the surface of the land but under the concrete. Under concrete and not under the ground doesn't make it subterranean. So unlike Sullivan that we've argued, we're not quite sure if the roots are really subterranean. We've argued, and Mrs. Kelly's status on the land as a co-owner versus an invitee is certainly an issue, but that would be an issue only for Mrs. O'Green, not for the city of Naples. But according to Marion versus Boca Raton, there's an independent duty to maintain and also warn. In this case, the judge didn't rule on a duty to warn, on a duty to maintain. The trial court only ruled that she had constructive knowledge. Under this court ruled, and I believe Judge Northcutt, you were part of that decision, in Cold Storage versus Barone. And I'm sorry I didn't find this earlier, but in Cold Storage Cafe versus Barone, which is located at 779 Southern 2nd, 371, 373, back in 2000, the issue of whether a negligent condition exists on premises is generally an issue of disputed material fact that would preclude summary judgment.
But wouldn't that be a disputed fact as opposed to between the invitee, licensee, and trespasser and the owner? That wouldn't be a disputed issue between co-owners, would it?
That would be a disputed issue between the city and Kelly, sir. But it would not necessarily be an issue between...
But see, the city doesn't own the sidewalk, and that's where she fell. She didn't fall off the sidewalk in the right-of-way. She didn't fall on any property the city owns.
She fell or she tripped over a raised portion of the driveway because we're in the city's right-of-way. So and there's a question of fact of who has to maintain that right-of-way, because the homeowner is not allowed to touch the tree according to the city ordinance.
No, her testimony is she parked in an area on the driveway where she never parked before. She goes in, she picks up a 25-pound concrete urn. She's carrying it out over a driveway that's been there for 50 years and never been paved, and she can't see down, and she's looking straight forward, and she falls and falls, unfortunately falls on the urn.
Yes, sir.
on the private driveway. She didn't fall on the sidewalk or right adjacent to the roadway. It was on the driveway right 2 feet from her car.
But the driveway has that 30-foot right-of-way on it. And the
driveway
record isn't
extends-
clear.
The driveway extends across the right-of-way.
The driveway extends through or across the right-of-way. There is, the
didn't
record
she-
says that the
didn't
right-of-way
she
is
fall-
30 feet.
But didn't she fall on her driveway? Yes or no?
That she's listed on the deed, so technically she's entitled to part of the driveway. But she doesn't occupy the property.
And she has the right to maintain it too, doesn't she?
She does, according to the law. However, since 1995, she's testified that she didn't live there, she did visit frequently, and she doesn't do anything to maintain or inspect the premises because that's what her mother does. With that, Your Honor, I see that my time is eating into my rebuttal time, so I will cease and allow my colleagues to continue.
Sure.
Good morning, may it please the court. My name is Scott Cole. I'm here on behalf of Ms. O'Green. With me is Christopher Donovan. He's here on behalf of the City of Naples.
Are you guys going to divide your time?
Judge Northcutt, normally one of us would argue for both, but since there may be issues unique to the city that the panel may want to discuss, I'm going to take 15 minutes. He'll take 5. I don't believe I'll need all 15 minutes.
Okay.
So we'll divide it like
And
that.
Mr. Donovan is injured, so he might not be
Yeah,
able to.
he may have trouble getting up here. The panel clearly understands the issues in this case, and by the questions asked, it is clear that the panel, the questions indicate our position in the case is that as an owner, Ms. Antoshka does not fall within one of the 3 categories that a duty is owed by a property owner. She is not an invitee, she is not a licensee, she is not a trespasser, she is an owner. Therefore, no duty is owed to her to maintain the property in a reasonable, safe condition. No duty is owed to her to warn of any concealed perils. I think, Judge Sleet, when you asked counsel 2 key questions during his presentation, his concessions pretty much shut the door on at least our position in the case. First, if a third party came onto the premises and tripped and fell, he or she could sue Ms. O'Green as well as Ms. Antoshka. And second, Ms. Antoshka fell on a portion of the property that she owns. There is no case in Florida that says an owner owes another owner a duty to maintain or a duty to warn. And I believe the panel's questions indicated that the review of the Metzger case and the Arias case was similar to ours. Metzger and Arias were cases where a possessor of land was saying that they had no liability to a third party injured on the land because they were not the owner. This case involves an owner saying she is owed a duty from a co-owner, and quite simply, no case in Florida stands for that proposition. With that said, we'll rest on our briefs, and we ask the court to affirm.
Thank you. Thank you.
May it please the court. As counsel just introduced, I'm Chris Donovan, and I'm here on behalf of the city. The city adopts the arguments with respects to the ownership and co-ownership lacking duty to another owner, and certainly to a third party who has absolutely no property interests in the driveway or Ms. O'Green and Ms. Kelly's property. I thought, though, that I would add 2 additional points that are distinct to the city. The first is the city wasn't really addressed in the initial brief. In fact, we're more or less an afterthought, or sort of lumped in with Ms. O'Green. And the only instance in the initial brief where Ms. Kelly challenges the trial court's decision that Sullivan versus Silver Palm Properties controls is on page 31 of the initial brief, and that is in relation to the fact that they argue that the trial court didn't provide written findings of fact and conclusions of law, which is simply not required in a summary judgment order. It wasn't necessarily clear to the city whether or not they were specifically challenging the application of Sullivan, so we went ahead and did it in our brief. It wasn't until the reply brief that we came to the conclusion that they apparently didn't like that aspect of the decision either. In fact, the reply brief exceeds the page limit in order to address the city's arguments, and I would suggest that at this point, with respect to that distinct issue, it has been waived for purposes of appeal, and that this court, at a minimum, must affirm because they've failed to address the Sullivan argument. But if this court is going to entertain it, then I would suggest that Sullivan applies here. The Sullivan case states that an adjacent property owner has no responsibility for the injuries caused by subterranean root growth. Counsel for Ms. Kelly just spoke and stated that that she tripped on the driveway that she tripped on a driveway that was in the city's property, and I'm not entirely sure that's correct. I'm not sure that that's clear from the record. What is clear from the record is that she tripped on the driveway, and the city did not pave that driveway. Ms. O'Green paved that driveway, and it's part of of Ms. O'Green and Kelly's property, and it's their burden to maintain it, to repave it, which it has not been paved in 50 years, 50 or 40 years, I can't remember exactly. The fact of the matter is there's no evidence that these roots were visible, were above ground. I define subterranean as not visible, below ground, below some surface that would allow you to see it. And I think that's pretty much what the dictionary would define it as also. But there's no evidence of that. In fact, in the initial brief, she suggests that Kelly's testimony between pages 99 and 100 would show that they were visible, that the roots were visible. But that nothing in those pages, neither express or implied, would support that. In the reply brief, the counsel changes position and suggests that it's actually maybe unclear whether or not they're visible, and instead relies on the following quote from Ms. O'Green's testimony. In response to a question, were they visible, Ms. O'Green testifies, well, there's roots all in the yard, but you can't actually see it underneath. That's why I didn't notice it before. I simply don't see how this means they're visible, which is what counsel for Ms. Kelly is suggesting, that this is evidence that the roots were visible. To me, this is Ms. O'Green saying, I didn't see it, I didn't know it, they weren't visible to me. There is some evidence that she had contacted the city, albeit not in writing, which is required by the ordinance, but she contacted the city would come out and repair the roots that were in the greenway area of the yard of her personal property. But there's no evidence that anybody knew that the roots were heading towards the driveway, or much less causing a defect, that at the end of the day, even if the city had removed those roots, it would still be Kelly and O'Green's burden to fix the crack. There was no burden on the city to ever fix the crack. Therefore, I would respectfully, and one other final point. The argument that the evidence somehow shows that they are above ground and visible is contradictory to the pleadings. Her own complaint at paragraph 3, page 3, paragraph 11, says that they were under and around the driveway. That set up the entire summary judgment. If they're under the driveway, then Sullivan applies, and this court should affirm. Thank you, Your Honor.
Thank you.
Your Honor, loath as I am to read from a case. Under Metzger, it said, in a premises liability case, the issue of whether a party has a duty of care does not depend on ownership or title to the premises. Instead, the appropriate inquiry is whether the party has the ability to exercise control over the premises. That's on page 977. It quotes IAS that says, the liability of an occupant of real property for injuries caused by an alleged dangerous or defective condition on the premises depends generally on his control of the property, regardless of whether he has title thereto. And in this court, and Lukanich said, even if the city does not own the property, if it assumed control over the property, it also assumed the responsibility to exercise the requisite degree of care towards the various classes of persons. Yes, it is unclear under Florida law if a co-owner can be an invitee, a licensee, or a trespasser. There's nothing that says it can't. There is, arguably on the other side, nothing that says a co-owner can be. However, the duty of each co-owner is independent, and that would be a question of fact for the jury to determine, not as an issue of law or a question of law for a judge to dispose of the case finally. In this case, there were genuine issues of material fact where the roots were located. There were genuine issues of material fact as to whether Kelly had constructive knowledge. There were genuine issues of material fact whether the city was on notice from Mrs. O'Green. In this case, as a matter of law, the judge only ruled on one of the duties, not the second. And the second duty is a duty to maintain. With that, Your Honor, respectfully, the appellant would request that this court reverse and remand this case for further hearing. Thank you.
Thank you, Mr. White.